I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are at the door of number 194 on our compilation list. Today, we will be chilling out in the state of Michigan with two different judges. Before I give you their names, just remember there will be commentary left in from when these previously aired. Also, chapters will be added for your convenience. And now let me give you the rundown of the judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge Mark Slavens out of the state of Michigan. And second, we will be in the courtroom of Judge Simpson, as I said, also out of the state of Michigan, for a very classic sovereign citizen, somebody that really was heavy on the internet that we haven't really heard too much from in a while, but we definitely wanted to throw one of his proceedings up because we've seen so many from him that were definitely very interesting and probably some of the most watched sovereign citizen courtroom proceedings on the internet. So listen, this is 194. We are just chugging along. We're moving along here. Thank you, as always, for all of you guys' support. And now, here's 194.
All right, you can call Ms. Tubbs' case.
Okay. Following case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yeah. Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Your Honor.
Okay, then it says at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Your Honor.
Yes, Your Honor.
Right, then the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No medication.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What day?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed the notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my right to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under code UCC 1-207. And I have the rights to represent myself and waive all counsels knowingly, willingly, and intelligently. And I would like to.
Right,
That's
so
for
you're
the record.
requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm gonna voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, once I get that, then if she wants to represent herself, then we can,
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
That's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Sean.
So, ma'am, I'm gonna have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not gonna do it, but I just want you to talk with him and understand some of the risks of doing this. And, okay?
Your Honor, I understand all the risks and I do not wish to talk to him. I have not talked to him in 6 months, so why would I need to talk to him now? Thank you. I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him, is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're gonna need you to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions, just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I'm here to reserve
let's
my
have
right.
you raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you. All right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not
But I need to
having
know
you
what
present
oath,
yourself.
what oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right, well, let's have her raise her hand again and you say the oath, the affirmation. It's not an oath, it's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No, yeah, okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary, affirm.
All right, thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
But I understand what you're saying, but I waive that right.
Okay, do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
Punishable up to 5 years or a
It's-
fine not.
Ma'am, just wait. Let me speak, okay?
I'm
Madam
sorry.
It would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice. So that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5 years.
All right, ma'am, the maximum possible sentence in this matter is 7.5 years because you are a habitual offender second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay, so ma'am, first of all, can you give me your educational background?
I
How
have
far have you gone in school, ma'am?
college.
College, okay. And have you represented yourself before?
Yes,
And why do you wish to how many times have you represented yourself?
twice.
Okay, and then what were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract with you all as owning our vessels, and I'm tired of it. I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
The elements of this offense is that it's punishable by imprisonment for more than
No,
5.
that's not what the
Oh.
the elements of the offense are.
The elements? What do you
Yeah.
mean by elements? Because y'all
Well,
use double language.
that's the problem. You
Y'all
don't
use
know.
double language here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense? How are you going to do that, ma'am, if you don't even know what you have to defend against?
I have to offend against the accusations, the charges.
All right, ma'am, tell me what the rules of, do you know the rules of procedure?
The rules and procedures to this is
Yeah.
that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm a judge, okay? Ma'am,
Okay, so what?
ma'am,
so
no,
what-
you don't get to quiz me. Ma'am, what do you know what the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
Acceptance of the hearsay. Hold on, I want to write all this down.
I'm sorry. No, I'm asking you. You say you know this stuff. How are you gonna represent yourself?
You got
don't even know what.
acceptance of hearsay, sir. I would like to write everything you're
All right.
saying down so I can
Have
be
you
able to.
ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No. Do you know how to ask them questions?
Yes.
And how to do the jury instructions? All right. Do you know how to preserve issues for appeal?
Yes.
Do you know that self-representation is almost always unwise?
Yes.
Did you know that the first day of law school, they tell us that he who represents himself has a fool for client? Do you know they tell us that?
Yes.
And so what does that tell you if they say he who represents himself has a fool for client? What's that tell you, ma'am?
You know what it tells me?
Yeah, what's that tell you?
You all operate in trade secret acts. So
Okay. Well, that's not true, but okay. Miss Tubbs, would you do brain surgery on yourself?
Why would I do brain surgery on myself?
Yeah, because you'd have a fool for a patient, wouldn't you?
Correct.
So why do you think you can do law if you can't do medicine?
Because I go by federal law.
Okay. You understand you'll receive no special treatment and you can receive no help from the judge during the trial. You understand that?
I understand.
You understand the prosecutor is an experienced trial lawyer who is unlikely to give the defendant any special consideration. Do you understand that?
Yes.
You understand you'll receive no special help from the court staff and you'll be expected to follow the same requirements that apply to practicing lawyers. You understand that?
Yes.
Madam Prosecutor, have I complied with MCR 6.005?
Yes, Your Honor.
All right, ma'am, do you believe that your waiver of an attorney is knowingly, intelligently, and voluntarily made?
Correct.
And accurately and understandably?
Yes.
Okay. Then the court will find that the waiver is knowingly, intelligently, voluntarily made. The waiver is unequivocal. You understand the disadvantages of self-representation, and self-representation will not disrupt, unduly inconvenience, or burden the court. So I'm going to grant your request to represent yourself, ma'am, okay?
Thank you.
All right. Now we've got a jury trial. What's our date?
And I would like the full discovery package sent to me, please, as well with along with the Dr. Chef report and the oath of office, please, so I can know what I'm dealing with.
All right.
Do you guys just go by maritime law or common law?
Ma'am, it's not maritime law. You need to learn the law, okay? I'm not advising you on the law. I told you I'm not advising you. If you don't know what it is, that's up to you to find out. I'm not advising you on anything on the law, ma'am.
Don't worry about it. I know what it is.
Yep, don't ask for any special consideration. You have to perform just as any licensed attorney would here. So if you don't know that, I would strongly recommend you have an attorney represent you if you don't even know if it's a maritime law or not.
It's my right to ask questions.
All right, well, go ahead. As I said, he who represents himself, he or she is a fool for a client, ma'am. Okay, we will have the attorney send you those documents. Madam Clerk, if you can get a standby counsel for this for March 17th at 9 o'clock. Is there anything else we need to take up?
So am I here released?
Yes, you're released.
Thank you, Your Honor.
But you need to send all the materials to her. And also, if we can get her brought here from jail, Madam Clerk. Okay.
That's what I was going to ask for, is to have her written here and then another date before the trial date where standby and Miss Tubbs would be here, where we would all be on the same page.
Well, we're going to get the standby and do that right away as soon as we get that.
Okay.
I we can
request that,
schedule this for, ma'am, don't interrupt me. I don't interrupt you, you don't interrupt me.
excuse me.
We'll schedule this for February 19th at 9 o'clock for assignment of a standby counsel, okay? And if you can make sure that she is on Zoom that day, Madam Clerk? Okay. Is there anything else we need to take up with regard to Ms. Tubbs' case? And you, ma'am, just so it's clear, you're under oath. You are requesting that there not be an insanity defense. Is that correct?
That's correct. And I also,
Okay.
February 19th,
Madam
I
Clerk,
have
if you can
something
prepare,
scheduled at 9.
ma'am, don't interrupt me. Prepare an order that says that she's withdrawing any insanity defense. Okay? All right. What, Ms. Tubbs?
I have another court time at 9 a.m. on February 19th.
All right, then we'll make this February 20th at 9 o'clock. All right?
Thank you.
Good morning, Your Honor. Ashley Lottie for the people.
Sir, state your name.
I'm here on a special appearance, Your Honor. Magoo is Easy Elastical Trust, registered in Jackson County, on a case number 2522246.
Okay, is your name Daniel Magoo?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Mr. Magoo, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No, not at this time.
Let me then do this. You have two cases before this court, one being the case ending, well, let me get the full case number 25F40523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be
We've been
charged with
through this
something without a
before on
witness.
your other cases when you represent yourself, so we'll just do it.
You're talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services.
As I am here and as a trust, Your Honor, I am here in exclusive equity.
You count 2 on that complaint is the charge of operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization.
My license is
Count
canceled,
3.
not suspended or revoked. It is
Count 3
canceled through the state
on
of
that
Michigan.
complaint
Canceled.
is the charge of escape from lawful custody. That is a misdemeanor punishable by up to 1 year, a $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by
wishes
Washington
to
County
represent
prosecutor as
himself.
usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or for.
This is a matter under the Eastern District of Michigan Federal Court. Case number 2511226.
We're not represented by counsel. I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel would be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. Magoo has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25F309 or 0979, in that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count one is fleeing and eluding fourth degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
My Secretary of
two
State, anything
is
is canceled. I have
operating
no contracts with the state of
vehicle.
Michigan.
That is a misdemeanor.
This is a
charged
matter of
with
trust, Your Honor. This is a matter of trust.
punishable
I am
by
protected
up to
under a
90
trust.
days of jail, a $100 fine plus court cost. Count three on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court cost. Count four is operating while licensed, suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are
By
through
up
the
to
federal government.
days,
I have federal
$500
government
fine
registration.
plus
I do
court
not have
costs.
contracts with the
Vehicle could
state.
be subject to mobilization. Count five on that complaint alleges refusal to obey refusal to.
I have an international driver's
Police
permit.
officer. That is a misdemeanor punishable by up to 90 days, $100 fine plus court cost. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I stated in the other case also apply to this case.
Were you served your
And that
notice
if
and
the
summons
defendant
yet, Your Honor?
wishes to have counsel appointed, the court would consider or would appoint counsel to represent him in this matter. And he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you
Do
get your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
until you
bench.
Inform the court otherwise. Ms. Lundy.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time? on both
Well,
cases?
he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
All right. What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand.
Do you wish to have- do you wish to
There is
have a
no
preliminary-
there is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date, potentially.
Because you've got to send it.
Yeah, and who restricted
So,
my phone
probable cause
calls?
Conference, you know what?
Who,
You're gonna have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say. But I'm not gonna have you interrupt me and I'm not gonna have you interrupt the people when they're talking. As long as you were saying.
Thank you, Your Honor. I have to there's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that. And then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. As to bond.
Your Honor, I've been reviewing ex-jail and I wanted to double check if the defendant had been arraigned. It's not clear to me from a couple of different things, but It does appear that he has been set with a $10,000 bond in 25F30979, as well as 25F40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would like to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene from the sheriff's department in order to, for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel Magoo. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem going on. And I also think it's important for this court to know, because I don't know that the court knows, the defendant has a third new case, telecommunications malicious use with a domestic relationship, that is currently pending as well. He's also been set $10,000, 10% in that matter. But I think
Where is that case out of?
that case is out of 14B, Your Honor, before Judge Washington.
A co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year, where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low. And I also am going to request a scram tether, because this is an OWI fourth alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was an abuse of discretion, given the circumstances of this defendant, to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
No
I
victims.
do believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The police officer did not report that at all.
The court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash here. Thank you.
the tethers I requested, if he is able to post, Your Honor.
I will.
Thank you.
Thank you. If everybody doesn't mind, the court's gonna take a very brief recess, and then I will come back and we will finish them.
All right.
Well, guys, we've come to the end of this proceeding, and as we can see, Mr. Daniel Magoo has not changed one bit. Same arguments, constantly still talking about malicious prosecution, still talking about Judge Simpson is practicing law from the bench, all of the same arguments that he had before. I'm super surprised that Judge Simpson allowed him to talk over him as long as he did. Eventually, he ends up addressing it and telling him to cut his nonsense out, allow the prosecutor to speak, allow me to speak, you'll get your turn. But in the past, if you follow these proceedings with Mr. Magoo and Judge Simpson, and I'll put a link to those down in the description, there was some times where Judge Simpson had a very short fuse with Mr. Magoo to the point where he had Mr. Allen take him out a couple times. But with that being said, this thing is going to be prolonged into August 7th. We're going to see how everything plays out. As we can see, Mr. Magoo has been very busy, new cases. He's in 14B court now, where Magistrate Braley is, Judge Washington is. We know he ran off on Judge Slay, like I mentioned in the beginning. So it's going to be interesting how all of this plays out. I'm looking forward to seeing how it plays out. I just got to make sure I keep up with his proceedings, but with my little small business and working, stuff like that, sometimes I miss out on these cases and I'm unable to grab them before the courts get rid of them. But with that being said, guys, as always, I appreciate you guys. Thank you for everything that you do, the liking, the subscribing, the comments in the comment section. It is truly a pleasure. And with that being said, this is Sovereign Citizens Hall of Fame, guys. And for now, Sovereign Citizens Court is adjourned. I appreciate you guys. Stay tuned and God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.